If even one sentence of sworn testimony contradicts years of public claims, what happens next? It's a simple question, quiet, almost forgettable, but when asked inside the walls of the royal courts of justice, echoing between marble pillars and legal precedent, it doesn't just hang in the air, it detonates. But before we continue, please don't forget to like, subscribe, and turn on the notification bell for updates. Because in that courtroom, words don't float, they land, they bind. And for someone like Prince Harry, whose entire public persona has been built, challenged, and reshaped by narrative control, what's said under oath isn't just an answer, it's evidence. So let's begin with the moment everything began to shift, not in the tabloids, not in the social feeds, but in sworn testimony. The Duke of Sussex, seated under the cold, scrutinizing light of cross-examination. A legal war with the British press reaching its boiling point. The headlines call it a privacy battle. A David versus Goliath clash between a wronged royal and a ruthless tabloid empire. But that's not the real story. The real story is about contradictions. Some subtle, others impossible to ignore. The kind that don't fade with time. The kind that raise questions, dangerous ones, not just for Harry, but for the institution he once belonged to, and the father he once stood beside, King Charles III. Now here's where it gets strange. As Harry returned to London's High Court this week, the cameras were fixed on him, of course. The press gallery was full, the headlines were pre-written, but something else was happening behind the scenes. Not in the courtroom, but in the palace. Because it wasn't just the Daily Mail's defense team poring over every word. It wasn't just legal clerks documenting each breath taken under oath. It was, quietly, unspoken, the firm, the crown, and perhaps even the king himself. And according to sources, ones will examine in due time, that silent observation may no longer be silent. Not after this week, not after what was said. There's something important you need to understand, especially if you've only followed the surface-level headlines. This trial, Prince Harry versus Associated Newspapers, is not the first. It likely won't be the last. But it may be the most pivotal, not because of what it alleges, but because of what it reveals. Harry has accused the publisher of the Daily Mail and the Mail on Sunday of illegally gathering private information. That's the core of his case. Surveillance, voicemail interception, invasions of privacy stretching back years. But here's the twist. In order to prove that, Harry has had to recount, and essentially cement, a version of events from his past. Dates, feelings, betrayals, conversations. Moments that until now lived in the elastic, flexible space of personal memory and controlled interviews. Now, they live in court records, and the contradictions are starting to emerge. Let's be clear, contradictions alone don't mean someone is lying. Memory shifts, emotions color recollections, trauma distorts timelines. But legal systems don't operate in the abstract. They operate in comparison between what's said under oath and what's been said before. In Harry's case, that means comparing testimony to interviews, to podcasts, to his Netflix docuseries, to his memoir Spare, and to a string of public statements, many made emotionally, many made years apart, that are now being held up against cold, adversarial cross-examination. And somewhere in that pile, something triggered alarm bells, not just for the defense attorneys, but for someone else. Because reports, some faint, some persistent, suggest that King Charles may have had enough. That behind palace doors, legal counsel is being summoned not to assist, but to defend. That Charles is not just concerned, but prepared, to protect the institution, to protect the monarchy, even if that means acting against his son. Now you might be thinking, surely not. Surely it wouldn't go that far. A father taking legal steps against his own child, that's the reflex. But pause, because this isn't just a father-son rift. This isn't about Thanksgiving awkwardness or estranged Christmas invites. This is about the crown, the monarchy as a legal and constitutional entity. And when the institution is threatened by scandal, by leaks, by sworn testimony that could implicate the palace or contradict decades of royal messaging, inaction becomes risk. Ask yourself this. What would you do if you were the king, and your own son's courtroom testimony began to unravel the very foundation of your institution's credibility? Would you issue a public statement, distance yourself behind the scenes, or Would you quietly begin preparing something far more decisive? Because according to those with knowledge of royal legal strategy, something is being prepared, and the stakes are higher than ever. Let's rewind for a moment. Earlier this week, Harry took the stand again. The mood was different from past appearances, less defiant, more weary, but still pointed. He maintained his position, insisting the tabloids had violated his rights, attacked his wife, and turned his life into fodder for profit. And many watching sympathized. It's not hard to imagine the trauma, the relentless intrusion. But then, the defense began its questioning. And here's where the air shifted. Under oath, Harry repeated claims that he had made before, but this time, with legal gravity, about when he learned certain things, about who told him what, about what was or wasn't known inside the palace. Except, some of those claims don't align with the record. Some contradict what he wrote in Spare. Others directly oppose things he said in media appearances just months earlier. And that's not just awkward. In court, it's dangerous. Because the defense doesn't need to prove malice. They only need to prove unreliability. And they're building a case, not just against Harry's accusations, but against Harry's credibility. And if that credibility cracks under cross-examination, it doesn't just jeopardize this lawsuit. It triggers aftershocks that could ripple back to other claims he's made. About the palace, about family members, about events he says happened behind closed doors, events the palace has never publicly contested until now. So let's talk about the silence. The royal silence. That cold, composed, calculated silence that Buckingham Palace has mastered for generations. The refusal to comment. The no statement at this time. The carefully chosen absence of defense or denial. It's easy to mistake it for passivity. But royal silence is an absence. It's latency. And what we're hearing now, through whispers, back channels, and credible leaks, is that latency may be ending. Because when silence becomes a liability, the next step is an outrage. It's litigation. And that brings us to the heart of this expose. There is growing speculation that King Charles may be preparing a legal response. Not through press releases. Not through courtiers whispering into Daily Mail columns. But through lawyers, through the Crown's legal advisors, through formal, strategic action. And while nothing has been confirmed publicly, yet, the signs are mounting. The palace has begun privately questioning some of the claims made in Harry's sworn testimony. Questions are being asked internally about whether these statements, now on record, could damage the monarchy's reputation, especially if left uncontested. And perhaps most ominously of all, there are quiet conversations about whether allowing these contradictions to stand, without challenge, sets a dangerous precedent. Think about what that means. If the king allows his son's testimony to exist uncontested in public record, even if it's not directly about the palace, what message does that send? To the press? To future claimants? To Parliament? To history? And so, sources say, there's a simple phrase beginning to circulate in the halls of power. Call the lawyers. It's not a threat. It's not a promise. It's preparation. Because for the monarchy, risk isn't measured in headlines. It's measured in erosion. Now, before we continue, understand this. We are not here to declare guilt or innocence. We are not here to litigate Harry's trauma, nor to deny the very real abuses of tabloid culture. This isn't a personal attack. It's an institutional dissection. Because when narrative collides with evidence, when memory confronts legal scrutiny, and when family becomes entangled with constitutional duty, something has to give. And in the next hour, we're going to follow that tension step by step. We'll walk through the testimony, the statements that don't quite align, the moments where the story wobbles, and the quiet decisions being made behind the gates of Buckingham Palace. Because what's unfolding here is more than a lawsuit. It's a credibility reckoning, a royal fault line, and perhaps the beginning of a confrontation no one wanted, but no one can now avoid. But what came next would change everything, and no one saw it coming. A courtroom isn't built for storytelling. It's built for exposure. That's the first thing you need to understand. What might move an audience on a podcast or tug at heartstrings in a best-selling memoir holds no power under oath. No weight, no warmth, no leeway. In court, empathy is not evidence, and emotions don't override contradictions. Because when you're sitting across from a defense lawyer, it doesn't matter how heartfelt your words are. What matters is whether they add up. Prince Harry walked into that courtroom with the burden of his entire public history behind him. Not just the trauma, not just the headlines. The record. His record. And it's that record. Years of interviews, television specials, published words, spoken truths, that is now being measured against the sworn statements he made in front of a judge. It's a sharp transition, from my truth to legal truth, and those two things don't always align. Let's look at what actually happened. When Harry took the stand earlier this week, it was, on the surface, yet another battle in his ongoing war with the British press. The case itself is focused, at least officially, on illegal information gathering tactics by associated newspapers, voicemails, surveillance, intrusions into personal life. But the path to proving that is messy. It required Harry to walk through the events of his life, specific ones, step by step, not as memories, not as metaphors, but as timelines, dates, sequences, who said what, when, and in what context. It's not the kind of setting where you can generalize or speak poetically. It's forensic. And in this environment, even the smallest inconsistency becomes a crack in the structure. One of the most scrutinized moments came when Harry described how, and when he learned he was being targeted. How early he believed the press had begun tapping into his life. Who warned him, what evidence he had, and most critically, what conversations were had inside the palace when it all began. But here's the catch. Those moments, they've been described before, not just in passing, but in vivid, emotional detail, in Spare, in Oprah's interview, in Netflix specials, sometimes with slight variations, other times with dramatic flair, because those were stories told to shape a message. In court, however, there is no message, only fact. And when the defense started laying those timelines side by side, the gaps started to show. Now, this might seem minor, a few differences in how events were described, but it's not, because under cross-examination, credibility isn't about intent. It's about precision. It's the difference between saying, I remember feeling unsafe, and on April 12th, I was told my phone had been hacked. One is emotional, the other is concrete. And when both versions exist, especially when they're in print and on camera, they collide in court. And that's where things start to unravel. Let's be clear about the stakes here. This isn't a matter of Harry being caught lying. That's not what's being argued, at least not directly. This is about whether his testimony is consistent with his previously stated version of events. If not, the defense can argue that his recollections are unreliable. And if he is unreliable, then so too is the entire foundation of his claims. And that, right there, is where everything shifts. Because once credibility is in question, the defense doesn't have to dismantle every accusation. They only have to show that the storyteller can't be trusted as a consistent narrator. That's the strategy. Chip away. One line, one contradiction, one quote from Spare placed next to one courtroom response. No outburst, no drama, just erosion. And it's not just the defense that's watching. Sources suggest that legal advisors connected to the palace have begun reviewing the transcripts, too. Not publicly, not officially, but carefully. Because here's the silent risk. If Harry says something under oath that involves the palace, and if that statement contradicts a past public statement or internal record, then it's not just his credibility on the line. It's the institution's. That's when internal alarms go off. That's when phones start ringing. And that's when a line gets crossed between emotional family fallout and constitutional exposure. Imagine, for a moment, you're in King Charles's position. You've maintained silence, dignity, distance. Your son has gone public, but you've held your ground. You've resisted the urge to fire back, because silence protects the crown. And besides, you're still his father. But then, a sworn statement is made, and it doesn't align with what you know to be true. And worse, if unchallenged, it will sit in the public record forever. What do? Say nothing, and let history misremember, or step in, not emotionally, not personally, but legally. This is what makes this moment in court different from all the others before it. This time, the contradiction isn't just between Harry and the press. It's potentially between Harry and the palace. And it's happening under oath, where words can't be massaged later, where testimony can't be edited for clarity, where contradictions don't fade, they calcify. And here's where it starts to get really uncomfortable, because some of those contradictions, they're not minor. We'll examine them in depth soon, but even before we get there, it's worth noting the pattern. On topics like when Harry learned about certain press tactics, whether or not he was warned by royal aides, what internal discussions happened about phone security, what advice he received, and from whom. These aren't abstract debates. They are fact-based claims, with dates, with names, and some of them, well, let's just say they don't all match what's already been made public. Not by a little, by enough. Enough for defense attorneys to circle in red ink. Enough for royal legal teams to start cross-referencing their own internal communications. Enough for those quiet, ominous words to surface once more. Call the lawyers. But what really triggered that response? What single contradiction may have finally pushed the palace toward legal intervention? We're not talking about rumors now. We're talking about one line, buried in hours of testimony, that may have changed everything. And we'll unpack that next. In memoirs, memory is flexible. In court, it's evidence. That's the line no one wants to hear, because it cuts deep, especially when you've spent years controlling your own narrative. When your voice, your pain, your truth have been repeated across platforms, podcasts, best-selling books. But here's the thing. In a courtroom, your truth doesn't matter if it can't survive scrutiny. And that's what makes this moment so dangerous for Prince Harry. Because suddenly, memory isn't a safe place. It's a liability. Let's walk carefully here. We all misremember things. Names, dates, the order of events. Especially when trauma is involved. Especially when emotions are high. That's not rare. That's not criminal. That's human. But legal systems don't weigh memories in terms of how they feel. They weigh them by how consistent they are. And if you're trying to prove a pattern of illegal surveillance, over years, across outlets, you need one thing above all else. Chronological, consistent recollection. That's the framework Harry's case depends on. The moment he says, "This happened here," or "I only found out then," the timeline locks in. Every word that follows must fit. If it doesn't, the entire case becomes vulnerable, not just to rebuttal, but to dismantling. Here's where it begins to slip. Under oath this week, Harry was asked about when he first became aware of being targeted by tabloid journalists. Specifically, when he first suspected his voicemails were being intercepted. The defense pressed hard. Why? Because in previous interviews, Harry had described years of discomfort, a sense of being watched, a gut feeling, occasional warnings from aides. Intuition, vibes, all understandable, but this time he needed a date, a fixed moment, and the date he gave, let's just say, it didn't align cleanly with other public comments. In Spare, for example, there's a passage that implies he knew far earlier than what he testified. That's not just a storytelling inconsistency, that's a contradiction on the record, and one contradiction is enough to call an entire testimony into question. Let's step back. Think about how memory functions when you're not being challenged. It bends toward narrative. It fills gaps with emotion. It reshapes itself to match the tone of the moment. That's what makes memoirs feel real. But the courtroom doesn't allow that fluidity. It freezes memory in place. It demands you explain how you remember something. What triggered it? Who told you? What you did next? Suddenly, "I just felt something was wrong" becomes a trap. Because if you felt it then, why did you say you only realized it later? If you suspected in 2005, why did you testify that 2009 was the moment? And if you wrote in your memoir that you confronted someone at the palace about it, why under oath did you say you never raised concerns until years later? That's not a smear tactic. That's a legal tactic. And it works. Because once those cracks appear, once memory becomes malleable, they can be widened. One question at a time. One document at a time. One clipped quote played back with surgical precision. This is exactly what the defense is trying to do. Not prove that Harry wasn't hacked. Not even prove he's lying. Just prove he can't be trusted to remember the sequence of events. And if that's the case, then the accusations themselves become vulnerable. The timelines become unreliable. The cause and effect collapse. Now let's talk about emotional cost. Because this isn't just legal. It's personal. Harry is not a trained legal strategist. What happens when someone's version of their life, told through years of interviews and advocacy, is suddenly subjected to a cold, forensic audit? Is that unfair? Or is that exactly what courts are built to do? It's a brutal collision, one that turns pain into paperwork, one that turns deeply personal trauma into cross-examination material. And for Prince Harry, it's becoming clear, this trial isn't just about what happened. It's about how reliably he can remember what happened. And how well that memory holds up when lawyers sharpen their knives. You might wonder, why does this matter so much? Why are we talking about slight differences in memory when the real issue is whether the press broke the law? Because contradiction is the strategy. The defense doesn't need to prove Harry wasn't hacked. They just need to prove that Harry's story can't be relied upon to prove that he was. And once the doubt exists, once jurors or judges see the gaps, everything else begins to feel unstable. It's the legal equivalent of removing one screw from a metal frame. Nothing collapses right away, but suddenly, the whole structure feels wobbly. And in law, that feeling is enough. Which brings us to the palace. Because this isn't just affecting the outcome of this trial, it's threatening something larger. Harry's sworn testimony isn't limited to tabloid actions. In describing what happened, he inevitably describes conversations, reactions, responses. Inside the royal institution, inside the family. And if those descriptions don't align with previous accounts, then the palace, by extension, is implicated. That's what we hinted at before. That's why lawyers are being called. Because every memory under oath that touches the palace, even indirectly, becomes their liability, too. And while Harry's team might argue that these inconsistencies are minor, the palace doesn't view it that way. Not when the monarchy's credibility is being passively shaped in someone else's courtroom testimony. Not when ambiguity starts to sound like implication. Not when the silence of the crown is being filled by a narrative it didn't authorize and can no longer ignore. So now we're here. Prince Harry, under oath, describing a timeline that conflicts subtly, but unmistakably, with the timeline he's publicly shared before. The press is watching. The defense is circling. And inside the palace, a decision is quietly being made to intervene or to prepare. Because what Harry said next wasn't just a contradiction. It was a direct reference to a royal aide, to a conversation behind closed doors. And that single reference may have finally crossed the invisible line. Not every reaction to testimony is public, but some silences are louder than statements. The world has been watching Prince Harry's legal battles like a Netflix courtroom drama. Paparazzi shots outside the High Court. Headlines screaming about royal showdowns. Analysts breaking down his testimony as if it were a sports game. But they're only watching half the stage. The other half is behind the curtain. Because while the press zooms in on Harry's face during testimony, on the other side of that public spectacle, something quieter is unfolding. And that silence, it's coming from Buckingham Palace. And it's not the kind of silence that means nothing is happening. It's the kind that means everything is. Let's talk about what silence really means in this world. In most families, when a loved one starts making public claims, there's a confrontation, maybe even a messy one. Angry phone calls, family group chats erupting, long emails, cold shoulders. In the royal family, there's protocol, structure, denial through inaction, statements that say nothing while signaling everything. And so far, the palace has kept its distance. No comments, no clarifications, no defenses. Harry has spoken freely across platforms, interviews, docuseries, books, and the royal institution has stood still like a stone wall, proud, cold, immovable. But here's the twist. This time, they're not staying still. They're just staying silent. Sources close to royal legal advisors have suggested that the palace began paying closer attention the moment Harry's courtroom appearances became more than just tabloid-related. The moment they started touching the edge of internal conversations. The moment Harry invoked, however subtly, what was, or wasn't, said by people inside the palace. Not gossip, not perception, statements, events, people. The defense team, as we've covered, is focused on inconsistencies. But the palace, they're focused on exposure. And in this trial, exposure doesn't mean secrets being leaked. It means official misrepresentation of what took place inside an institution bound by tradition, discretion, and, critically, public trust. Here's where it gets real. Harry, in his testimony, mentioned being advised by a royal aide not to escalate certain press-related issues. A moment where he allegedly brought forward his suspicions about surveillance, phone tapping, and was met with a kind of shrug. That's huge. Because if true, it implies the palace knew. And if false, It implies Harry just put something on public record that never happened. Either way, the palace has a problem, one they can't afford to leave unanswered. Because here's what's at stake. If Harry's version of events is left unchallenged, it becomes part of the historical record. It doesn't need to be proven right. It only needs to survive scrutiny. And if that record shows the palace ignored his warnings or downplayed his concerns about illegal press behavior, that's not just a family issue. That's a failure of institutional duty. And the monarchy does not absorb that kind of failure lightly. Let's pause for a second. You might be wondering, okay, but where's the proof the palace is even paying attention? They haven't said anything. Exactly. They don't need to. But journalists who've covered royal affairs for decades are starting to notice a shift. Fewer background briefings, more closed doors, communications teams on tighter lockdown, and, most tellingly, legal consultants being looped into internal conversations. Because the palace doesn't prepare to respond in the press, they prepare to respond in court, if needed. And that preparation? It's not noisy. It's not rushed. It's deliberate, cold, unforgiving. Ask yourself, what does the palace gain by staying silent forever? Nothing. Because each word Harry says under oath, each detail that touches the palace, whether about aides, family conversations, or withheld support, becomes precedent. And precedent is dangerous. Because once it's set, it frames every future narrative. Inaction becomes agreement. Silence becomes complicity. And history doesn't care if the palace simply chose not to engage. History will write, this was said, and it was never denied. That's not a footnote. That's a stain. And that's why insiders are now suggesting the silence is tactical, not passive. A pause before motion. Because the royal strategy has always been one of containment. Control the narrative not by shaping it, but by outlasting it. But in this case, they may not have the luxury of waiting. Because this isn't a leaked headline. This isn't a rogue documentary. This is sworn testimony in a court of law. And the longer it sits uncontested, the more it ossifies into accepted reality. So the palace faces a choice. Let the narrative form without them, or intervene, quietly, legally, surgically. And sources close to royal operations say that the latter is now on the table. Here's what that intervention could look like. Not a counter lawsuit, not immediately, but something more subtle. An official inquiry into the claims made under oath. A private legal request for clarification or retraction. An internal audit of the alleged conversations involving royal aides. And if contradictions are found, if there's no record of the conversations Harry described, if there are internal emails, minutes, or witness accounts that refute his timeline, then the palace may move, not with fury, but with precision, because this isn't about punishing Harry. It's about protecting the institution, the brand, the legacy, the legal standing, and the press. They're watching, but they're watching the wrong side of the room. They're watching Harry, every stumble, every breath. What they're missing is the flicker of movement behind closed doors, the call that was made, the briefing that was held, the lawyer who's now reading transcripts, not out of curiosity, but out of duty, because the palace doesn't watch passively forever. They absorb, they calculate. And when they move all at once. So here we are. Harry's testimony is now etched in court record. His version of events includes not just accusations against the press, but implications about the palace, about conversations he claims took place, about actions or inactions that suggest the monarchy looked the other way. And still no royal response. But the silence has changed. It's no longer neutral. It's preparatory. And what comes next may not be a statement. It may be a subpoena. Because the next chapter doesn't start with Harry's voice. It starts with what he said about a very specific person, and what that person is now prepared to do. You don't need to prove someone is lying. You only need to prove they're uncertain. It's a quiet legal truth, and the cornerstone of how defense strategies like this one are built. Because in a courtroom, truth isn't about who cries harder. It's about consistency. And when the opposing party is a public figure with years of emotional storytelling behind them, you don't attack the pain. You don't even attack the story. You attack the structure. And that's exactly what Associated Newspapers is doing. Let's get something clear right away. This case was never about exposing Prince Harry's trauma. The Daily Mail's legal team isn't there to argue over whether Harry suffered. That's not their job. Their job is much colder. It's to prove his testimony can't be trusted. Because if it can't be trusted, if it bends, contradicts, or falls apart under pressure, then the entire premise of the case begins to collapse. Not because Harry doesn't deserve privacy, but because he can't prove it was taken from him in the way he claims. This is the kind of strategy defense lawyers live for, not because it's flashy, but because it's lethal. So how are they doing it? Not with spectacle, not with cheap shots, but with a slow, grinding, methodical approach to discrediting sequence, memory, and motive. Here's what we know. Their entire focus right now is on creating a pattern, not of dishonesty, but of uncertainty. They don't need to say Harry lied. All they need to show is that Harry's version of events has shifted over time. In legal terms, that's called inconsistency of material fact. In jury terms, it's doubt. And doubt is the enemy of evidence. Now let's examine a specific tactic they're using. They're matching sworn testimony to published material. That means everything Harry has said in interviews, documentaries, speeches, his book Spare, even statements made by Meghan, are now potential reference points. Not as gossip, as contradictory exhibits. Let's say Harry claims in court that he found out about the phone tapping in 2010, but in Spare, he writes that the suspicion first hit him in 2005, after a conversation with William. That 5-year discrepancy, it may seem small, but to a defense attorney, it's a crack. And cracks are where you insert leverage. They don't need to call him a liar. They only need to ask, which version are we supposed to believe? They're also going after the sources of his beliefs. Much of Harry's claim relies on what he felt at the time, a sense that something wasn't right, a feeling that he was being watched. Conversations remembered in fragments. And that's human, that's real. But in court, feelings aren't facts. So the defense uses that vulnerability against him. They ask, who told you your phone was hacked? When exactly did they tell you? Did you confront the person who gave you this information? Do you have proof of that conversation? And when the answers are vague, when the responses sound like approximations, that's when the damage is done, not because the answer is wrong, but because it isn't concrete. This is what makes courtroom strategy so brutal. It doesn't reward passion. It punishes imprecision. And in a case where the plaintiff has built his credibility around emotional memory, that's exactly where they press, over and over again, until the emotional resonance of Harry's story, the very thing that made it powerful in public, is rendered fragile in legal light. Here's another tactic they're using, shifting burden. It sounds technical, but it's actually very simple. When Harry makes a claim, say, that his voicemails were intercepted by a journalist, they demand evidence. If he says he was told this by someone, they ask for a name. If he names someone, they ask for documentation of the conversation. If he doesn't have it, they frame the lack of proof as unreliability, not malicious intent, just doubt. They chip away at the foundation, slowly, precisely, until the story, while still emotionally compelling, no longer meets the burden of legal proof. And that's all they need. Let's not pretend this is neutral. There is something uncomfortable, even predatory, about how these defense strategies work. They're designed to take messy, emotional, very human experiences and flatten them into timelines and contradictions. They're meant to corner witnesses into moments of uncertainty and then exploit that hesitation as weakness. But that's the reality of the system, and Harry's team knew it going in. Which is why this courtroom battle was always going to be about more than truth. It's about who controls the narrative when the rules of storytelling are stripped away. And while the public may still see this as Harry versus the press, the defense is playing a longer game. Because every time Harry misremembers a date, or revises a claim under pressure, or walks back a previous implication, they're creating a shadow record. A parallel narrative, one where Harry isn't a victim. He's an unreliable narrator. And that narrative, that's what they want the judge and the world to remember. Which brings us to something subtle, but deeply important. There's been speculation, quiet, not confirmed, that Associated Newspapers may be collecting more than just quotes. They may be coordinating with other media organizations to map out Harry's interviews across time. Why? Because each time Harry has spoken publicly about press intrusion, he's created a data point. And when those points don't align, the defense will use them, not because the truth isn't in there, but because contradiction is enough. And contradiction, in court, is devastating. Now you see why the palace is getting nervous. Because while Associated Newspapers is defending itself, it's also constructing a timeline that implicates more than just Harry. If he says he told aides certain things, or that he received warnings from inside the palace, and those statements are now officially contested, then the monarchy itself becomes part of the contradiction. And that is why, behind the scenes, lawyers at Buckingham Palace are not laughing at this case. They're studying it, because the outcome doesn't just affect Harry's lawsuit, it shapes the historical record. And that record is already being written, one cross-examination at a time. But what happens when that shadow narrative, the one the defense is quietly building, conflicts with the palace's silence? What happens when even they can't stay quiet? Because something Harry said next didn't just contradict the press, it contradicted the palace's own internal documentation. And now, it may be too late to walk it back. Books are permanent, testimony is binding, but what happens when they don't match? This is the part of the story no one wants to admit, even those closest to it, because it starts with something that, at the time, felt powerful, necessary, even healing. When Prince Harry published Spare, it was hailed as a breakthrough. Raw, vulnerable, honest, a man shedding layers of royal insulation to speak in his own voice for the first time. But here's the legal reality. Every sentence in that book is now admissible. Every anecdote, every timeline, every recollection. Because the moment Harry took the stand under oath, his memoir stopped being a personal artifact. It became a source of evidence. And if what's in the book doesn't align with what's said in court, that's not just awkward, it's strategically devastating. Let's start with the obvious contradiction. In court this week, Harry described a moment when he first suspected the press had begun targeting him. He referenced a specific conversation, quiet, behind closed doors, with someone close. A royal aide, allegedly advising him to let it go. Move on. Don't poke the bear. But in Spare, here's where the damage begins to spread. Harry's legal team may argue that Spare was never meant to be a precise legal record, that it was a personal retelling, an emotional lens. And that's probably true, but the defense doesn't care, because they're using Spare not to prove wrongdoing, but to create doubt. They're stacking his testimony alongside excerpts from the book, then saying to the court, these can't both be true. It's not aggressive, it's surgical. They're not accusing him of perjury, they're simply disqualifying his certainty, one paragraph at a time. Let's go deeper. There's a particular moment in Spare, a passage where Harry talks about feeling completely alone in his suspicions about the press. He implies that the palace offered no support, that no one believed him. But in court, he testified that he'd been told by internal advisors that hacking was likely, that he was warned, that there were discussions behind the scenes confirming his fears. Now, those two things can't coexist. Either he was warned, or he wasn't. Either he felt abandoned, or he was told what was happening. And this isn't just a minor narrative drift. It changes the entire emotional foundation of the story he's told the world. And if the court decides that foundation is unstable, then his entire argument becomes less persuasive, not false, just fractured. And fractured is all the defense needs. This is what legal strategists call the memoir trap. It happens when a high-profile witness has previously published a public-facing narrative and then enters a legal process that demands precision over emotion. It's a trap because the earlier version, often shaped to resonate with public sympathy, becomes an albatross in court. Every poetic line becomes potential evidence. Every metaphor becomes a point of contention. And suddenly, what once felt like reclaiming your voice starts to sound like you can't keep your story straight, even if you can, even if it's honest. This, perhaps, is one of the unspoken dangers of fame. When you live publicly, when your pain, your growth, your trauma are all broadcast and monetized, your own history becomes searchable, cross-referenceable, vulnerable, and Harry, to his credit, has tried to own that vulnerability again and again, but in a courtroom, owning your pain doesn't protect you from being cross-examined on it. There's also a deeper layer here. Spare wasn't just a book, it was a weapon, a strategic move in the larger war over legacy. It painted the palace in sharp relief, cold, callous, indifferent. And now, in court, every sentence that pointed fingers back toward the monarchy is being parsed. Because the book didn't just criticize the press, it implied complicity from the palace. That's what raised eyebrows back then. And that's what's raising legal concerns now. Because Harry's courtroom testimony seems to soften some of those implications, at least in part. He's more cautious with his words, more restrained, as if the weight of legal consequence is pulling him back from the edges of the rhetoric used in the book. But the book still exists, and it doesn't pull back, which means, functionally, there are now two versions of the same story in the public record, and the palace is watching both. Because here's the real risk. If Harry's memoir paints the palace as negligent, and his testimony doesn't fully confirm that timeline under oath, then the monarchy isn't just hurt reputationally, it's put in a defensive position, one where it may be forced to respond. And that response, it might not come in the form of a statement. It might come as something much colder, a legal filing. There's one more contradiction worth mentioning. It's subtle, but it matters. In court, Harry was asked about when he first started documenting his suspicion of press intrusion. He hesitated, said he wasn't sure. But in Spare, there's a vivid scene describing him writing down his thoughts, journaling suspicions, tracking moments that felt off. That scene is detailed, confident, unambiguous. And yet, in court, that clarity vanished. And once again, the defense pounced. Because when memory fails under oath, but thrives on the page, doubt creeps in. And that's the memoir problem. It's not about exaggeration. It's not about intent. It's about contrast. Two versions of the same man, one shaped for public empathy, the other boxed in by legal truth. And the more those versions diverge, the more exposed he becomes. To the press, to the court, and, perhaps most dangerously, to the palace itself. Because as the contradictions stack up, one behind-the-scenes question is being asked with increasing urgency. What else in the memoir doesn't hold up? And what happens when that answer isn't theoretical anymore? What happens when it's tested? When the monarchy says nothing, it doesn't mean they're uninvolved. It means they're choosing the battlefield. That's the thing most people get wrong. The royal family isn't just a family, it's an institution. And institutions don't speak casually. They don't react to every claim, every insult, every headline. That silence you hear, it's not apathy, it's calculation. And in this case, with Prince Harry's courtroom testimony now extending its reach beyond the press and into the perimeter of the palace itself, that silence has shifted. It's no longer a pause. It's a strategy. Let's go back to something subtle. When Spare came out, there was no formal rebuttal from Buckingham Palace. None was expected. The institution has survived wars, abdications, death scandals, and Diana. It knows how to take a hit and wait. But this time, with testimony happening in a legal setting, with Harry speaking under oath, describing internal conversations, accusing unnamed royal aides of suppressing key information, the stakes have changed. Because in a courtroom, words don't just echo. They linger. They're recorded. And if those words are about the palace, and they go unchallenged, they become part of the accepted record, not just in the public sphere, but in the historical one. And the palace knows this. Which is why silence, in this moment, isn't passive. It's preparatory. Royal watchers have been trained to read between the lines, to analyze how many paces behind the king someone walks, to decode the jewelry choices of senior royals, to interpret no comment as either peace or quiet war. But this isn't about symbolism. This is about legal maneuvering, and the signs are all there. Insiders say that legal advisors, once hovering quietly in the background, have now been drawn directly into conversations about Harry's testimony, not just as observers, but as participants, advisors, strategists. That doesn't happen unless the palace believes it's at risk. And the risk here is that the monarchy gets dragged, bit by bit, into Harry's lawsuit, not as defendants, but as unwilling co-narrators of a story they never intended to tell. Let's be clear, no one inside the palace wants a war with Harry, but the palace has an obligation that goes beyond blood. It has to protect the crown. That's not personal, that's constitutional. And if Harry's public testimony creates the appearance that senior members of the royal household ignored, mishandled, or actively silenced evidence of press intrusion, especially illegal activity, that's not just bad press. That's potential institutional failure. And if it's allowed to stand, the credibility of the monarchy takes a hit that can't be walked back with a photo op or a Christmas speech. It would sit there forever, uncontested, in the record. And the monarchy has never been in the business of letting its own destruction be documented passively. Here's the other problem. Timing. Because this isn't happening in a vacuum. It's happening during a critical period when the monarchy is already attempting to reposition itself post-Elizabeth. King Charles's reign is still being defined. Public trust is still forming. William and Kate are shouldering more symbolic weight. And in that fragile reshaping of the royal image, testimony like Harry's can be catastrophic if left unanswered. Because once the idea forms that the palace knew but didn't act, or the palace silenced its own, it doesn't matter whether it's proven in court. It sticks, and that kind of narrative doesn't just wound, it metastasizes. You can already feel the tone shifting inside the British media. Where once reporters danced around royal legal involvement, now they're quietly naming names. Legal firms with previous ties to the monarchy are being mentioned more frequently. Former palace insiders are being consulted off the record. Public relations strategies are being cross-checked with legal timelines. It's subtle, but it's real. The palace isn't denying Harry's claims, but it's also not ignoring them. It's watching, gathering, waiting, and eventually acting. Now think about this from their perspective. If you're Buckingham Palace, and you've endured months, years of accusations and interviews and memoirs, your instinct is probably still to stay above the fray. But this is different. Because now it's not just reputational, it's procedural. If Harry's testimony is allowed to remain on record without pushback, and if that testimony references internal meetings, aide conversations, warnings allegedly given or ignored, then the palace can no longer say it wasn't involved. Because now it is. Not by choice, by implication. And the only thing worse than being accused is being accused and saying nothing, because then silence sounds like agreement. Here's the part that should really raise eyebrows. According to at least two well-placed sources in the legal reporting circuit, there's been an internal audit of communications mentioned by Harry in his testimony, emails, briefings, meeting notes. The palace is checking its own records. Why? Because if Harry claims something under oath that can't be found, that didn't happen the way he said it did, they now have two urgent obligations. Correct the public record. Prepare for legal separation from the narrative. In plain terms, that means building a legal firewall between Harry's testimony and the monarchy itself. And that process has already begun, quietly, without a press release, but unmistakably. This is how the palace fights. Not with headlines, with lawyers, with historical precedent, with reputational engineering, and most of all, with silence that doesn't last forever, just long enough to be strategic, and just short enough to be devastating. The irony? For years, Harry accused the palace of being cold, of refusing to support him when he needed them most, of hiding behind phrases like, "recollections may vary," instead of taking responsibility. But now, as his testimony becomes a potential liability for the crown, that same coldness is being sharpened into something else, something more pointed, something legally actionable. Because while Harry is telling his truth, the palace may be preparing to challenge his accuracy, not in a public interview, not on television, but in a court submission, backed by documentation and royal authority. And so, the question becomes, if the palace breaks its silence, if it finally speaks, will it speak as a family, or as a legal institution? Because there's a very real possibility that the next time we hear from the monarchy, it won't be through a speech. It'll be through a filing. You don't need to lose a lawsuit to suffer its consequences. That's the uncomfortable truth no one wants to face, especially in a case like this, where public perception is already in flux and the institution involved is as fragile as it is historic. Legal exposure doesn't always look like guilt. Sometimes it looks like silence becoming unsustainable. Sometimes it looks like a question being asked in court and left hanging in the air unanswered. Sometimes it looks like damage, permanent, unshakable, even if no one is ever officially found at fault. Let's step into the palace's mindset again. At this point, Prince Harry has issued sworn testimony that implicates not only the press, but the royal establishment itself. He's described moments of internal inaction, implied knowledge on the part of unnamed palace officials, suggested there was a willful decision not to protect him from a legal intrusion. He's named no names. But that's almost worse. Because the implication spreads like smoke, it clings to the curtains. And inside the monarchy, implication is almost as damaging as proof. Because unlike tabloids, they don't operate in the world of scandal and rebuttal. They operate in legacy, and legacy doesn't survive well in ambiguity. This is what we mean by exposure without a verdict. Let's say the court ultimately sides with Harry. He wins damages. The press is found culpable. Fine. But in the process, if testimony suggests the Crown stood by silently, if aides appear dismissive or unhelpful or vaguely complicit, then Harry's win becomes the monarchy's loss. And what if Harry loses? What if the court finds insufficient evidence? Even then, exposure has already done its work. Because the most damaging details don't always make it into a judgment. They live in transcripts, in viral headlines, in the public's selective memory. The courtroom becomes less about outcome and more about what becomes permanent in the public consciousness. This is the trap the palace finds itself in, not because it made a move, but because it didn't. It didn't preemptively clarify, didn't preemptively defend. And now, the institution is tethered to someone else's narrative, in a system where no formal judgment is even needed to cause permanent harm. It's enough that Harry's words are on record, enough that royal legal teams are reacting, even if they won't admit it. Enough that journalists are now quoting not from leaks, but from court-certified transcripts. And those transcripts will exist forever, in archives, in documentaries, in future books about the monarchy's slow erosion. That is legal exposure without a verdict. Let's turn to a real-world analogy. When a corporation is accused of wrongdoing, they often win in court, but still bleed out in the press. The stock price falls, public trust dips, board members resign, not because they lost in court, but because the process itself exposed them to scrutiny they couldn't withstand. This is no different. The monarchy may never be named in this lawsuit, but it's already been dragged through it, by implication, by omission, by what's been said and what hasn't. And it's not just the palace that faces this quiet unraveling. It's Harry too. Because if he's found to be inconsistent, even if not dishonest, that inconsistency becomes a wedge between him and future credibility, between him and allies who once stood with him publicly, between him and the narrative control he's so carefully maintained since stepping away. You see, verdicts are clean, but exposure is contagious. It doesn't stay contained to one headline or one court appearance. It creeps into every room, and once it's there, no one gets to pretend they weren't involved. There's also another layer to this, the institutional timeline. The monarchy operates in decades. Harry's case will be resolved in months, but what it leaves behind, those contradictions, those implications, they'll be weaponized for years. Every future crisis, every anti-monarchy campaign, every radical tabloid expose will reference this case as precedent, not necessarily because of the ruling, but because of what was said, what was uncorrected, what wasn't denied, what lingered. And here's where the palace may be quietly panicking. If they speak now, publicly, they validate the importance of Harry's claims. They open themselves to further questioning. They risk reinforcing the very narrative they've tried to rise above. But if they don't speak, they allow those claims to ossify, to harden. And then it's no longer Harry says X. It's Harry testified under oath that X, and the palace said nothing. That distinction, it will matter when history books are written. It will matter when documentaries are made. And it will matter when the next scandal hits, and people start searching for patterns. This is why institutions like the monarchy fear courtrooms, even when they're not parties to the case. Because courtrooms fix memory. They force narrative to solidify into statement. They create permanent records, not just of what's true, but of what was claimed. And once a claim is made, on paper, under oath, its impact is no longer dependent on truth. It's dependent on persistence, on whether it's corrected, on whether it's challenged. And in this case, the palace's silence is doing something it didn't expect. It's granting Harry's version of events a kind of default legitimacy, even if no judge ever says so, even if no ruling confirms it. It's sitting there, untouched. And every day that passes, it hardens. So what now? Does the palace file something? Do they release a targeted statement? Do they allow legal intermediaries to challenge specific points in Harry's testimony? Do they risk turning silence into a confrontation? Because they're already exposed. And the verdict? It may no longer matter, because the exposure is already complete. But the next move, that may change everything. Because just as the palace watches Harry Harry may be watching them too, and if they flinch, he may already know how to use that moment. Every case has a point where concern becomes action, where watching is no longer enough. This is that point. Not when something is said, but when it sticks. Not when the palace is mentioned, but when the implication can no longer be ignored. For weeks, arguably years, Buckingham Palace has stayed quiet, not just in response to Harry's media claims, but to the drumbeat of legal consequences growing louder around them. They've trusted their silence. They've counted on the monarchy's age-old shield, distance. But distance only works when the line is clear. And now, that line is gone. Let's focus on what changed. Up until now, Prince Harry's case against Associated Newspapers was, technically, his fight, his story, his alleged victimhood at the hands of a predatory press. A familiar headline in the UK, echoing the ghost of Diana, framed as a modern David versus Goliath. But something shifted during his last round of testimony, a subtle moment. Maybe too subtle for casual observers, but not for lawyers. Harry described an internal conversation with a senior royal aide. The context was familiar. Fear of phone hacking, evidence mounting, stress escalating. But the language he used? It landed differently this time. He didn't just suggest indifference. He suggested awareness. That a palace aide knew. That they acknowledged the likelihood of a legal intrusion. And more than that they advised him not to pursue it. Now pause. Think about what that implies. It's no longer just the palace didn't help me. It's, they knew something criminal was happening, and they wanted it buried. That's no longer a personal complaint. That's institutional complicity. And while Harry didn't name names in open court, the defense doesn't need names to follow the signal, and neither does the palace. Because if the monarchy did receive legal or intelligence briefings about press behavior, and if they did choose to suppress or downplay it, and if that suppression is now on record, unchallenged, then something has crossed over, from narrative into exposure, from suggestion into risk. This is the threshold, the moment the palace can no longer afford to remain a passive character in Harry's legal drama. Because while they're not defendants in this case, they're becoming referenced witnesses. And in the eyes of history, and potentially the law, that's enough. Because even in the absence of a subpoena, even without formal charges, there's a question now forming. Did the institution of the monarchy knowingly allow its own members to be harmed? Because confronting the press would cause greater disruption. And if that question continues to circulate unanswered, the silence will become deafening. We've seen this play out before, not in royal courtrooms, but in public scandals involving large institutions, the Catholic Church, major corporations, government departments. There's always a threshold. The moment when internal knowledge becomes external implication, the moment where the silence that once protected begins to incriminate. The monarchy is no different. Its immunity is cultural, not legal, and culture moves faster than law. Sources close to royal advisors are now saying, off record, of course, that a tipping point has been reached. There's talk of preparing official denials, of issuing formal clarifications through intermediaries, not directly from the king. There's even early-stage discussion, we're told, about creating a timeline of internal actions, not for public release, but to protect the institution if this ever escalates beyond the current trial. Why prepare a timeline? Because legal advisors have one job: limit liability. And right now, the risk is clear. If Harry's testimony, as it stands, becomes part of a successful ruling, if a judge or ruling body references the royal household's apparent inaction, then the crown becomes something it has never publicly admitted to being before, a character in the failure. And that is historically and constitutionally unacceptable. This threshold moment is also strategic. If the palace acts too soon, it looks defensive. If they wait too long, they risk being framed retroactively as complicit. So they time it. They watch the coverage. They monitor public sentiment. They measure how loud the silence has become. And then, precisely when it can still matter, they will move. And not necessarily against Harry. They may move around him. They may release evidence to neutralize specific claims. They may allow carefully placed media leaks to correct certain dates or statements without ever issuing formal rebuttals. They may even allow third-party spokespeople, former aides, retired staff, to begin speaking in their personal capacity. All of it choreographed. All of it deniable. but all of it timed to reverse momentum. Because this case is no longer just about hacking, it's about responsibility. And in the British monarchy, responsibility doesn't fall on individuals. It rolls upward. Everything eventually leads to the crown. And if it's left too long, responsibility becomes ownership. And ownership, in this context, could be catastrophic. So what happens now? That depends on how far Harry goes. He's already pushed farther than many expected. He's put emotion on the record. He's challenged both the press and the system that allowed them to thrive. But if he continues to name the culture, if he begins to name the people, if he walks past implication and into accusation, then this moment will no longer be about whether the palace should act. It will be about how fast they can. Because if the next testimony, if even one sentence, explicitly alleges that a senior royal knowingly allowed a criminal act to occur without intervention,